Hello, everyone. Welcome to Court with Krissy. While I'm not a lawyer and have never taken Lawyer 101, I have watched my fair share of Law Talk with Mike. And what did I learn from Law Daddy? Any lawyer who represents himself has a fool for a client. Perhaps Mr. Ryman skipped that day of class. I hope you like it. Court with Krissy is now in session.
Hello.
Okay, looks like we've got everybody connected. We'll go on the record in Ryman versus Johnston. This is case number 2319394. Looks like Mr. Ryman's connected, as is Mr. Couch on behalf of the defendants.
Yes, good afternoon, Your
Honor. Hi. So we're on the record here today for motion. Mr. Ryman filed a motion for sanctions. I did have a chance to review that motion. Mr. Couch, I did receive your response, so I had a chance to review that. Mr. Ryman, anything that you wanted to present today by way of oral arguments toward your motion?
Yes, Your Honor. Thank you. I'd first like to note that in Mr. Couch's response, he didn't really deny any of my assertions or allegations. He just basically said, well, Mr. Riemann called Wolf one time when he said he didn't receive the notice of the January 6th pretrial on a different case. And also, even if we didn't serve him or we can't prove we served him, we did file it. So that should be sufficient under the court rule. It's not sufficient under the court rule. And Your Honor, the reason I hearken back to the original answer to the complaint is that they said the same thing at the time. Okay, we didn't serve it on you properly and timely within the court rule, but we did file it. So therefore, you're not entitled to the default, which the court agreed with. I just want to note that it's the same tactic, and it's continued throughout this case. And I'll touch on that with the request to admissions a little bit. I didn't include all of my correspondence with counsel to show that it was really a deliberate deception. It's as clear as I can be about it. So I'm asking for relief, Judge, for discovery sanctions. And although Mr. Couch says that the case law supports that the court shouldn't enter a default without a prior discovery order being violated, I would note that I cited the court rule, and the court rule does include language for failing to provide discovery up to and including the sanctioned default. I would ask the court, if you do not consider that, to consider the other remedies I requested, including an order extending discovery. And I would ask the court to enter a specific order requiring the Johnstons to produce themselves for their own depositions, as well as their experts. And I would ask the court to consider including in an order that they be required to do that at their cost. I have been through the ringer through no fault of my own. Judge, you'll see, I think in the exhibits that I attached, there's only one party that's obstructing and obscuring. I have tried to do a smooth discovery with Mr. Couch and his colleagues dating back to September of 2023. And I've just been ignored. So after Mr. Couch first came into the case in March, this is referring to the depositions, Your Honor, he said he couldn't do them for 60 days. And I apologize, in my motion, I said that he agreed to March 9th. He actually agreed to May 9th. So the court extended discovery. We set the defendant's depositions and my deposition by agreement for May 9th. On May 8th, Mr. Couch had his secretary email that he was canceling those. He needed to cancel. So then I went through the process of formally setting them by notice of deposition. I did so on June 19th, on July 15th and 16th, and eventually the latest round of disrupted discovery ended up having me set them for November 1st to try to get them in before discovery ended, because there was a dispute over whether or not they provided other discovery, which I didn't learn about till the last week of October. So I asked Mr. Couch simply to agree, like me and Mr. Carey did on the related Prather case, to just leave discovery open and we can take it as necessary. When he didn't respond, then I noticed the Johnson Depps and their experts, and he just simply ignored them. He didn't seek a court order. He didn't seek intervention. Just like with the June and the July dates, he did not receive the court's permission to skip the Depps or a protective order. He just skipped them. And that's what got us past the point of discovery. And Your Honor, I made a mistake in not raising this previously to the determination on the motion for summary disposition. I did believe that with the witnesses I presented, we would get past that and then we could address all this. And I just didn't want to confuse the issue. But it is something in fairness. I should have been able to provide the Johnston statements, and I should have been able to ask their experts, hey, did you know that one of my claims is that they changed my driveway? And yes, right now it angles to my house and that's why I'm flooding. But did you know that previously the witnesses stated all of the water flowed in the other direction away from the house? And one witness has testified that she watched Mr. Johnson change it to the other direction and change the flow of the water by her own eyewitnesses. I should have been able to ask the experts that. That would have been helpful to the court on that issue. So that is why the depositions weren't taken, Judge. They just didn't honor the notices, and they obstructed and obscured my efforts going back to September of 2023. With respect to the request to admit, this is a mandatory court rule. The punishment or sanction for violation of discovery in other respects is left to the discretion of the court, and it's anything from an order about discovery all the way up to default. As to request to admit, those are a special kind, and the court says that they are deemed admitted unless they're responded to within 28 days. The second part of that rule says they have up to 42 days to serve plaintiff if the request to admission are served with a complaint. So as I stated in my motion, that kind of makes it clear what they're talking about is response, is filing and serving, that's what's considered response to request to admit. And here we go with, again, what I think is an obvious intentional effort by Mr. Couch to make it appear like he served me, but he knew that he did not. And what's the end game there? The end game was he also filed a motion to strike my request to admit, and noticed it for hearing. And throughout that time in early October, Mr. Couch and I are having communications, and I'm sort of feeling him out as to why he didn't answer them. That shows that he knew they were not answered, or I was not aware that they were answered. Then we have Mr. Couch's paralegal, Brian Stevenson, emailed me on September 25th. Now, this would be 2 days prior to when they're deemed admitted. And Mr. Stevenson provided me the expert report that the court's aware of, and again, apologized and promised that the rest of their experts' reports, which I've still never received, were forthcoming. Those have been promised to me. I'm entitled to them, even under initial disclosures, but certainly throughout discovery and my formal discovery requests, I still don't have those expert reports. I cooperated. I got them in on May 2nd to inspect my home, and they're just simply not providing discovery. But Your Honor, with the request to admit, this goes a little further because Mr. Stevenson didn't mention the request to admit on September 25th. Mr. Couch in none of his October communications until finally October 17th, after I said, well, look, you didn't respond. They're all deemed admitted. Where do you want to, where do we go from here? Do we want to set a hearing on damages? That's when he finally said, oh, we mailed them on September 20th. I've shown the court, Mr. Couch hasn't responded to this at all. I've shown that on September 20th, they mailed me a single small envelope containing 3 pages, 1 stamp for a different case. That would have been that time frame, but that's all I received. I did follow it up, and they apparently were aware of it because the court clerk told me that they subsequently received that document 6 days after it was mailed to me, and that their procedure was to send that back. So by all accounts, Mr. Couch was aware that he didn't serve me. The other thing of interesting, and I did note this, Your Honor, I appreciate that I already told you this in the motion, but this is the only document he claims to have ever mailed to me and not emailed to me. Now, he says something in his response that, oh, Mr. Riemann, he's improper and he should pay attention, and he asked to be served by email. That's not true. Very early on in the case, I suggested under the court rule, why don't we all stipulate and sign an agreement to do service by email as opposed to service by mail under the court rule? It has to formally be changed by an order of the court with stipulation of the parties. Not one of the attorneys responded to me. And yes, we have been operating when there's been an acknowledged service of email, that we have been operating with that. But I have been sending my documents by regular mail under the proper service and by email as a courtesy. And that's all I asked for them to continue with as a courtesy, send me them. As to Mr. Couch's claim that I cried wolf on the January 6th incident, Your Honor, that was a mistake on my part. We did receive 2 notices of pretrial, and that was brought to my attention by my mail neighbor who opens my mail, because I get the notice that says I received 2 notices. He opened them and said, "Oh, they're both notices for pretrial with Judge Mertz. One is on the morning and one is in the afternoon of January 6th." He did not know and notice the different caption for the insurance case. So I hadn't recalled this when it came on the record. I was surprised that I missed it. I did call the court clerk when we noticed that confusion, and the court clerk advised me that it was set for the afternoon. And of course, they didn't know that I didn't notice the different caption for the morning one. So that was completely my fault, but that's what happened on that. I received the notice delivery, I received the notice delivery from my mail service. We just made a mistake as to it. Under the court rule, I believe, Your Honor, because they didn't file and serve me, whether you find it was negligence or intentional, those should be deemed admitted. And that is every aspect of the case, every aspect of it, except the amount of damages. And those have been filed, and I do believe that I'm entitled to that relief. Finally, Your Honor, I've also asked for default, and I would ask the court to consider it based on the numerous improper filings and violation of discovery and preclusion of any discovery at all throughout this case. The default should be considered. But I want to take the court back. The reason I started with their answer, where they got cute and said, well, we filed it, we didn't serve it, but we forgot, or we didn't realize it. Your Honor, that answer is not signed by any lawyer. Now, this is very basic pleading and practice in the court rules and common lawyer 101. The court rules say, and that's 1.109E2, it's cited in my motion, every document must be signed, every pleading must be signed. They go on to say in 2.508, the jury demand can be attached with the answer, and in this case, a counterclaim, which was also not signed. At the end of the answer, then they put the counterclaim, and then they put the request for relief, and then they put the jury demand, and that was electronically signed. 2.508 says the jury demand is a separate document from the answer. So, and it's on a separate page. They signed the jury demand. They did not electronically or in any other way sign their answer. And the court rule says, that's still 2.109E3, the court shall strike that pleading unless it is promptly signed after it's brought to the attention of counsel, which I attached Exhibit 22. When I was not served with the answer, I went to the courthouse, made a trip up there, and I noted that Ms. Lehman did not sign it. So I sent her the email, and it's attached, and it says, you know, I noted you didn't sign it as the lawyer. And, you know, I kind of respected that because the answer is all false. There's lots of false statements about the stone channel, et cetera. But that still hasn't been filed. And that it's way past. It's more than a year and a half past its time to be served properly, signed properly. It should be stricken, and the default should be answered or entered for failure to file an answer to this case. And I attached as my final exhibit a proposed order that strikes the answer and enters a default. So based on all of that, Your Honor, I've been put through the ringer. I have not done anything improper. All my services have been proper. Theirs haven't. They didn't answer the request to admit. They didn't serve them. They didn't permit any depositions of the Johnstons or the experts, and they played it right out to the end. So I didn't have enough time after November 1st to properly notice a motion before discovery expired. And I didn't want to, do something outside of the allowed court rule notice provisions. And finally, they haven't filed an answer. They filed a lot of improper pleadings. Default is the proper remedy, and I would ask the court to enter that.
All right, thank you. Mr. Couch?
Thank you, Your Honor. I'll be very brief. Mr. Riemann is objecting to matters that were settled by the court when partial summary disposition was granted to the Johnstons on the water damage claims. As I argued to the court, this instant motion is nothing more than a motion for reconsideration by a different name. Mr. Riemann did not timely file his motion for reconsideration. And so now he files this motion for sanctions, or so he calls it, asking the court to essentially grant the same relief. At the end of the day, he's also seeking summary disposition, so he clearly has not provided the defense with enough notice. But Your Honor, I'd like to very briefly take the court back to November of 2024. I filed a motion to strike the plaintiff's request to admit, because if the court recalls, he did not also, pursuant to the court rules, file them with the court. And the court went through the arguments both ways. I was asking that they be stricken because Mr. Riemann didn't file a copy with the court pursuant to the court rules. And at that hearing, the court said, look, you eventually did file service, and the defense answered, so we all moved on. And Your Honor, the court file reflects Mr. Riemann served them on us on August 30th. We actually answered them a week early, Your Honor. My secretary emailed a courtesy copy to Jennifer O'Rourke at the court. And the reason why they were mailed was because they were going back to everybody a week early. And we checked the court register of actions. It shows that they were filed on September 24th. Your Honor, Mr. Riemann, again, is complaining about many things that should have been addressed while discovery was open. He had a habit of arbitrarily picking days for depositions that I communicated to him were not good days for my clients. I asked him to work out a day with my secretary. He didn't do that. And then what he would do was wait until the very end of discovery and notice up depositions without the requisite time under the court rules. So for the several reasons set forth in our response to his motion for sanctions, we would ask that the court certainly deny the relief that he's seeking and hold the pretrial conference on the remaining claims that we just filed our second motion for summary disposition that will be heard in June.
All right, thank you. It's your motion, Mr. Riemann. Anything that you wanted to say in response?
Yes, Your Honor, I'll just answer a couple of the accusations of Mr. Couch. I did file my request to admit. There is no time frame set in the court rule for that filing. And I filed them with the same filing that I did the Prathers, and the Prathers were 3 weeks behind because it took me that long to do them. But I would note those were filed 6 weeks before the hearing on the motion to strike for not filing, and Mr. Couch was aware of that. The depositions were set by me eventually at the end of November, after I had been throughout the month of October asking Mr. Couch about his discovery responses and requests for dates. When I never got any, I finally just set them. That's the same with the experts. He never responded or gave me any dates. He wouldn't agree to extend discovery. And so I was coming up at the end of it, and I said, well, I just got to set them. If you want to adjourn them and give me dates and agree that they can be taken in November, that's fine. I just wouldn't get any response from him. So that's why that was done at the last minute. And that started back in February. I've attached the emails, February of 2023, where I was trying to take their deposition. Excuse me. So with respect to dates that Mr. Couch was not happy with, first of all, he gave me the July 15th and July 16th dates I used. He picked those, and I picked the 17th for mine. He subsequently said, well, the Johnstons aren't available. I'm available, but the Johnstons aren't. And I said, that's fine. If you tell me what they're, why they're not available, we'll work around it and pick any other dates. He hasn't done it. I asked in the request to admit that they didn't have anything else going or to tell me what it was, and they refused to answer it. So that's why they've never been reset. I gave gave Mr. Couch a 2-week window, and that's attached in my exhibits. Pick any day in those 2 weeks, and he refused to. So without getting them to agree to dates and canceling 2 dates that they had given me, I just picked dates out, 2 weeks in the future, and then offered to reschedule them if they gave me any conflict, and he would never give me a conflict. So I did everything I could, Your Honor. Maybe I should have more forcefully asked for orders earlier, but I did not expect that even on the last in October and November, they would skip them. And I don't think I could anticipate that. And the next day, discovery closed. So I think it's reasonable. It doesn't cause any prejudice to any party to allow me to take those steps and then present that information to the court. Thank you.
All right. Again, I had a chance to review the written submissions by the parties, taking that into account along with what both sides have had to say here on the record today. The request for sanctions was made pursuant to the court rules covering discovery violations, as well as the court rules for signing improper, frivolous, or harassing pleadings, or those which have no arguable legal merit. So I guess first looking at the discovery issues, I have no idea, other than Mr. Riemann, it was apparently your tactical decision to not raise these discovery issues. Why we're addressing these in April now, after the court has heard and ruled on motions for summary disposition. These are all issues that should have been raised by way of motions to compel in terms of the depositions, certainly before, or I mean, even after the close of discovery. Apparently, based on what you said today, Mr. Ryman, you made the tactical decision. You thought that your case was strong enough to survive summary disposition without compelling or seeking the court to compel those depositions prior to that point. Then you lose the motion for summary disposition on a number of your claims, and now you want to retroactively attack the discovery process. And you missed your chance. I mean, if this was going to be raised, it needed to be raised before the court heard and ruled on motions for summary disposition. I think there's some merit to Mr. Couch's point that this is really a retroactive motion for reconsideration by a different name, trying to attack what happened before the motion for summary disposition. In terms of the request to admit, same kind of thing. Like if you believed you had a basis for the court to find that the defendants had admitted liability on one or more of your claims, I have no idea why you wouldn't raise that at or prior to the motion for summary disposition hearing. But to lose the motion in the ways that you did, and then now try to claim that there were things that were done improperly before that, and now the court should reverse itself on its motion for summary disposition, order the discovery, and then essentially rehear the whole summary disposition issue. Number one, that doesn't make any sense. Number two, that boat has sailed, and you're a former attorney. You understand how this works. If you were a lay person, I could understand not getting the significance of those things in the order that things need to go in. But for you, there's just simply no excuse. And whether it was negligence on your part or a tactical decision, again, that boat has sailed. So I don't find any reason, and that's one reason. The other thing is, I think there is a lot of merit to Mr. Couch's argument that there were no orders compelling this, so they didn't violate any orders of the court. And I think that a violation of an order of the court compelling discovery would be required before the court could issue the kind of sanctions that you're asking the court to issue. Similarly with the pleadings, why now, more than a year after the responsive pleadings are filed, now you want the court to strike those again, way past the time where you should be attacking the pleadings, or where the court would consider granting you a default based on defects in the pleadings that's been out there for so much time. Certainly, if you believe you had an argument on that, it's incumbent on you to raise that argument in a timely manner. And to the extent that you haven't, the court would consider it waived. And again, I think it's disingenuous after you lose the motion for summary disposition to now try to go all the way back to the initiation of the case and attack things that happened then. Again, I don't think it's appropriate. I think any of those kind of arguments have long been waived. And again, I think you should know better. If you were a layperson, I might be inclined to grant some leeway there, but in this case, again, I don't find any reason to allow that. So the court finds that there just isn't a basis to grant any kind of discovery sanctions. There's certainly not a basis to grant a default based on some kind of defect in the response to pleadings that occurred at the beginning of the case. At this point, given the posture of the matter here today. The other thing that I would say is, and nobody's addressed this on the record, but I think it's important to address it. You know, Mr. Ryman, you make a lot of complaints about what the defendants have done in this case. You're accusing them of felony malicious destruction of property, insurance fraud and forgery, racism, putting statues on their porch reflecting racist themes. You're making these accusations against people. And I think it's important to acknowledge that because I think it's wholly inappropriate. And I can appreciate zealous advocacy, and I can accept that sometimes that kind of advocacy leads to some contentious statements and arguments and things put in print. But it's generally my philosophy, and it was as a practicing attorney and certainly is as a judge, that ad hominem attacks in general just are inappropriate when they're made against individual parties or against opposing counsel. They don't really have any place, in my view, in written or oral submissions because they just don't go to the merits of the case. They have nothing to do with the legal arguments, the legal issues, the legal claims that are made in most cases, and certainly not in this case. And the court has admonished both sides in this case early on, based on some of what I viewed as contentious and unprofessional statements. And defense counsel, to their credit, has largely refrained from that, except I think when they feel they have to defend themselves based on the comments that you've made, Mr. Ryman. But every one of your written submissions, Mr. Ryman, includes personal attacks, both against the defendants and opposing counsel. And again, they don't have any relevance to your claims. They don't have any place in written pleadings, certainly not an oral argument. And if you want to grind those kind of axes on your own time and using your own resources, that's up to you, but I'm certainly not going to allow you to use the court, use my docket, use pleadings filed in this court as a medium or a forum for you to engage in what I view to be inappropriate allegations and personal attacks that, again, have no bearing really on what's going on in this case. And I think they're inappropriate, and to the extent that they continue, whether or not the defense moves for any kind of sanctions, I think the court has the ability on its own motion to sanction that kind of conduct. And I find it completely inappropriate, and it just continues, and it appears to be getting worse given your statements, your accusations, which, whether true or not, certainly don't belong in this case. So the court certainly will consider sanctions to the extent that you continue to make those kind of personal attacks that are irrelevant to the claims. All of that being said, and overall, for all the reasons the court has stated, I find that the motion here should not be granted, and the court will deny the motion. I also want to address the motion for reconsideration that was filed pursuant to MCR 2.119. Whether or not it was filed in the correct timelines and served and so forth, the court is going to address it on the merits. I'm not going to hear an oral argument under 2.119 F2. There is no oral argument unless the court in its discretion allows that on a motion for reconsideration. But I do want to address it today rather than issuing a written opinion, since we're all on the record. The motion for reconsideration, number one, raised as one of the issues that the video that was submitted as an exhibit, the motion for summary disposition. which the court reviewed. Mr. Ryman, in your motion for reconsideration, indicates that that was ex parte. It was an ex parte. It was filed as an exhibit to the motion for summary disposition. Everybody had a chance to review it. So I don't view it as an ex parte communication. I don't know why you would assume that the court hadn't viewed it. I review everything that's submitted by the parties as exhibits or written submissions. And so I don't think there's any reason why the court shouldn't have considered it, or why it was inappropriate for the court to consider it, or why the court should give you additional time to argue about it. Again, that was the date set for hearing. Everybody had plenty of notice. If you wanted to argue about that video, that would have been the time to do it. You attempted to do that at the end of the hearing, but you had more than an adequate opportunity. Again, as I indicated on the record there, the majority of the oral argument during that motion was taken up by you. That you had more than an adequate time during your period that was allowed for argument to argue against that. And my ruling was simply I wasn't going to then allow you to continue to add new things to argue about at the end of the hearing, and the court had to move on. In terms of the rest of your motion for reconsideration, it really is simply re-arguing things that the court did rule on expressly as part of its ruling motion for summary disposition. To the extent there were pictures or other things that you would have wanted the court to consider under 2.116G5, certainly the court has to consider any documentary evidence that's filed or submitted is the language. In my view, holding up pieces of paper to the camera where I really couldn't see what it was, and in doing so muted my ability to hear what you were saying. To me, that's not submitting pictures for the court to consider or other documentary evidence. Those are things, as I told you at that hearing, that should have been submitted prior to the hearing. Just like if we were in person for oral argument, if you're at the podium and you're holding up a picture for me to view from the bench, that's not submitting it either. If we were here in person, I would expect if there's something that the court needed to view, that you would submit it to the court, so the court had a copy that I could view. So I don't find that you holding up pictures in front of the camera or other documents was submitting them pursuant to the court rule. There was plenty of notice prior to that hearing, plenty of notice that it was going to be by Zoom, plenty of opportunity for you to submit anything that you wanted the court to review or look at prior to that hearing. And you chose not to do that, and that was a decision that you made. So I think the court was appropriately not able to consider it because I couldn't see it. So again, the court doesn't, under 2.119, does not have to rehash its prior opinions. I'm relying on the record that I made and ruling on the motion for summary disposition. Your arguments and citation to the affidavits of your witnesses, I address those expressly on the record, I think individually. And so when I view your argument as a whole, it's really just disagreeing with the court's ruling, which is fine, and that's what appeals are for, and you're free to seek an appeal of the court's ruling, but I don't find that it points out any errors of the court as contemplated on a motion for reconsideration. So for the reasons I've stated here on the record, that motion is denied as well. Mr. Couch, I would ask you to prepare an order reflecting the ruling of the court today and submit that under the 7-day rule.
Thank you, Your Honor. I will. And I just have a quick question, a housekeeping matter. The court staff reached out to the attorneys a few days ago and indicated that the stay that the court previously granted with regard to the claim against the Prathers, apparently the clerk's office applied it to the entire case and then suggested that perhaps Mr. Riemann and I submit something additional clarifying that this portion of the case is not stayed. Would the court like me to include that in the order that I'm going to submit?
That's fine. I did address that today through staff with the clerk's office. They are going to correct the register of actions to reflect that only the Prathers portion of the case is stayed.
So nothing
And then-
further needs to be submitted by the parties?
No.
Oh, thank you, Your Honor.
And then with regard to the status conference today, because there is another motion pending, I'm going to adjourn out the status conference until the date set for that motion hearing in June. And once the court's heard that motion in full, then we'll go forward from there.
Thank you, Your Honor.
That's all I have for today. All parties are free to disconnect on this file.
Thank you, Your Honor.
Thank you.
Yeah.